Good afternoon, dear friends. You are aware, due to the corona effects, we are not taking the lectures in the class. But since we have sufficient time and yet the exams dates are not declared, let's have discussions over the rest of the chapters from the Evidence Act. Up to now, we have discussed up to section 58 of the Evidence Act. That is facts which need not be proved. Now here we are entering to the chapter 4, specifically very small chapter, but it's having very important aspects. That is with reference to the oral evidence. In this chapter, we'll discuss the oral evidence. In next lecture, we'll discuss the documentary evidence. Now, in order to prove the case, in order to prove the matter before the court of law, there are two types of evidence: oral and documentary evidence. Of course, the electronic evidence is there. It may be in both the format, or in the oral as well as in the electronic, that is documentary format also. That we'll discuss during the course of lecture. Now, during the course, we have discussed that the document exclude the oral, and therefore most of the students they are confused. What is the evidential value of the oral evidence? Does it mean that when there is a documents, oral evidence are not available or not allowed? Rather, the what is the evidential value of the oral evidence? Up to what extent they are allowed? What is the actual procedure of the under the Evidence Act? This has to be discussed while under the chapter 4, that is under section 59 and section 69, 59 and section 60 of the Evidence Act. Chapter 4 deals with the oral evidence. See, the evidence we have already discussed, we have already defined rather. Now, what is oral? What is evidence that is there? The evidence which is not documented, that is the oral evidence. This is what the simple meaning of the oral evidence is. Now, so far as the oral evidence is concerned, there are two rules that is deal with the oral evidence. One is that this is the basic principle that the all facts except, now this is most important. I'm not saying the word using the document. All facts except the contents of documents or electronic records may be proved by the oral evidence. And secondly, oral evidence oral evidence must be direct, it must not be hearsay evidence. Now, in short, under the Evidence Act, oral evidence is allowed on the basis of two conditions. First condition, that in order to prove any case, in order to prove any fact, firstly, that oral evidence must be direct evidence. It should not be hearsay evidence. Now, what is this concept of hearsay evidence? We have already discussed. Why it is not allowed? Why hearsay is not allowed? That we'll discuss, of course, here also. But the evidence should be direct. And when we can say it's a direct, when that particular evidence is perceived by the person by the five senses. That is what aspect we have already discussed. The five senses, I know, stays, all the aspect. Someone should be saw, someone should be feel, someone should be heard, someone should be watched, and therefore it has to be direct evidence. It should not be hearsay. This is first principle. Secondly, all facts except the contents of documents can be proved by the oral evidence. So most of the students, they are under impression when there is a documentary, nothing to do with the oral evidence. No. See the basic principle. It says all the facts except the contents. So, in short, in other words, in order to prove the contents of document, that document has to be proved by the parties in the court. But in order to prove the in order to disprove the documents, oral evidence is allowed. In short, in short, oral evidence is allowed except to prove the contents of document. Say for instance, let us take the example to in order to uh, curtail this chaos and the confusion in the minds of the student. Let us take the example. Suppose A agreed to B to sell his house, and there is a written contract between the parties. They have fixed the price, 10 lakh rupees. They have executed document. Now the moment word I use the word executed, that means the document is registered, and it's only agreement to say final sale deed has to be yet to be executed by performing the certain terms and conditions by the parties. Date of performance is also fixed. On that day, one of the party went to the other party, asked for the performance. It is refused by the other party, and one of the party files. Suppose hey, let us discuss a file a suit for specific performance of the contract, and if he come with the case that the price of the house is fixed at 10 lakh rupees, I have paid the 5 lakh rupees, and I am ready to pay the rest of the 5 lakh rupees. But the other party, that is the B, is not ready. Kindly direct him to execute the specific performance of the contract. Now he appear, he file a written statement. Of course, he deny. If he accept, there is no question of court matter, and therefore he denies. Now the chapter of burden of proof come into picture. Who has to prove what? And here A says it is written in the documentary evidence, while B say no, it is not fixed. Say for instance, for the sake of limits, the fact and issue, the disputed point between the parties is the values, that is the amount of the house. A say 10 lakh rupees, B say 15 lakh rupees. Now here the amount 10 lakh rupees is mentioned on the document, and that is what the amount A has said. Let us go with this principle. The contents of the document has to be proved by production of documents only, and not by the oral evidence. Now, if suppose A say in the document amount is mentioned 10 lakh rupees, in that case, the version, the oral statement of A is not allowed. He has to prove the document in the court of law, and therefore it says that all the facts except the contents of document can be proved by the oral evidence. If A say it is written in the document, he can't say orally. He has to prove the documents. This is what the characteristics of this particular oral evidence. And therefore, second characteristics, again, it should not be hearsay, it should be direct one. Why it's not be hearsay? Why it is to be hearsay? Because see the chapter. Earlier we had discussed relevancy and admissibility. I'm sorry, we have already discussed the relevancy of the facts. Right from section 5 to section 55 we have discussed relevancy of the facts. And now we are on the point of admissibility. Please bear in mind there is a difference between relevancy and admissibility. Sometimes rather the question examination. And therefore the title itself says that the fact, that is relevancy and admissibility, are two different aspects. There are several facts, there are several things, but out of that several facts, only those facts which are admissible, that can be taken by the court, that can be taken by the parties, and therefore sometimes questions, all admissible facts are the relevant, but all relevant facts are not admissible. What is this relevance and admissibility? Let us see. The relevance means the logical probability. They are relevant, logical relevance based upon the this probability. But so far as the admissibility concerned, it's a rule of law. It's a rule of law, and that rule of law, admissibility, has been provided from section 56 onwards. These are the aspects; those are admissible, while relevancy is from 5 to 55. 56 onward, they are provided for the admissibility of the evidence, and therefore here we are on the point of admissibility. Which factor is admissible? Oral evidence is admissible, subject to condition. It should be relevant, it should be direct, it should be to the point, and therefore section 59 deals with the proof of oral evidence. Now, what is this section 59 say? Proof of evidence. It says all fact except the contents of documents may be proved by the oral evidence. Say for instance, A committed murder of B, and at that time Mr. C is an eyewitness. Here he informed the police officer. Police officer came. Later on, Panchanama carried out. Charge sheet is filed. Now the matter is going on. In addition to the eyewitness, he has recorded this particular incidents of the murder on his mobile by using the camera of the mobile. Now he has two aspects here. That this is the best example which discuss the oral and documentary evidence. When the matter is going on, or rather in the during the course of investigation, when his deposition is recorded by the court, I'm sorry, the police officer, he informed the police officer, sir, I don't know who is the offender, but sir, when he was committing the murder, I put my camera on and of course the video on, and I have recorded the video record of that particular incident. Now this particular mobile become the valuable piece of evidence in the murder matter. Of course the person also. And accordingly police officer they take the they seize the police of as per the provision provided in the CRPC. They attach to the charge sheet. Now the matter is going on. Now he is deposing in the court of law. His personal deposition in the court of law called as oral evidence. And it is direct, it's not a hearsay. See the characteristics section 59 is required. Why? Because he was present at this time. He is the eyewitness. Okay, and therefore it is allowed as per section 59. Similarly, at the same time he say, sir, at that time I have recorded the incidents in my mobile, but that mobile is not produced in the court of law, then his version so far as that particular recording is concerned is not at all acceptable by the court of law, because law says unless that particular document is proved, contents cannot be proved by oral evidence. For that purpose, that oral evidence has to be there. I hope you understand so far as this aspect is concerned. Now, again, go to the next aspect when we go into the oral evidence. This particular section 59, it says that what is the oral evidence? Again, another question in the mind. Oral evidence means the person when it speaks, that is the oral evidence. Of course, it is by words. It is, but suppose the person who is an eyewitness to the particular incidents, he is a dumb. He can't speak. Does this mean that he is not a competent witness? He is. Then what? The sign or the gestures by the person will be considered as an oral evidence. Or suppose in cross-examination, the prosecution will ask him what has happened, and he has written in the court of law these incidents happened. Even though it is a written format, it is also called as an oral evidence. Only because it is written, that doesn't mean it's documentary evidence. The definition of documentary evidence something different, which we are going to discuss under section 62, 63, and all this aspect that we'll discuss later on. So this particular definition of oral evidence having a wider importance, and so far as evidence value of oral evidence is concerned, oral evidence is having more satisfactory or more uh, uh, satisfactory piece of evidence. Of course, compared to the documentary evidence, it's a less satisfactory, but it's very satisfactory. If there is absence of documentary evidence, then oral evidence will be considered as the base piece of evidence. But it depends upon the circumstances. Sometimes it's a wholly reliable, sometimes it's partly unreliable, partly reliable, or sometimes court can directly reject the entire oral evidence. Now come to the next aspect, that is with reference to section 60. It says oral evidence must be direct. Now, what is this? Why it's so direct? Because law expect that there should not be hearsay evidence. What is meaning of direct? What is direct? Does it mean that each and every incident should happen in the court of law? No. What is direct? The criteria is provided. Suppose, so if someone said I seen, then the person who saw it, he must be present in the court of law. Otherwise, if suppose I watch particular incidents and I went to my home and I narrated my incidents to my wife and she is deposing, that cannot be done. This is called as hearsay evidence. But the person who is the eyewitness, if he witnessed that, his version will be called as the direct evidence. Secondly, if someone heard, the person who personally heard, that his evidence will be the the oral evidence, direct oral evidence, or a person who is perceived by any other sense, heard, smell, taste. That is called as we pursue. His opinion must be there. Or in case of the opinion. Now, in earlier chapter we discussed the expert opinion. Say for instance, now why this pursue? So why I'm using this expert opinion? The person who perform the opinion, who come to the conclusion of that particular opinion, his version is most important. Let us take the example why it is. Say for instance, A mix the poison in the food of B, hand over to the B, B consume or eat it, and B dies on the spot. Body was sent for the post-mortem, and doctor Mr. Name is X, who was on that duty. He carried out the post-mortem. He take the viscera. He issued the medical certificate where he has mentioned the cause of death due to the poisoning, and everything he has mentioned attached to the charge sheet. Now, let us take the example. He was then that time particular posted in the Sassoon hospital. Now, from the investigation to the trial, it takes 10 years. And during these 10 years, this doctor was transferred to some other place. And now there is a new person who is appointed in that place. And when the witness is called, that new person came and deposed that yes, what you written in this particular report is correct. It cannot be done because he himself has not done the actual correct. This because he has not pursued. See, expert opinion is something different, but when personal has personally carried out something, that can be done. But he can only depose that yes, this kind of poison is dangerous to the health. That particular version is allowed. But whether the death is caused by that particular poison, he cannot depose because he has not carried out the post-mortem, and therefore the opinion must be there. But uh, uh, in some of the cases, in some of the cases, this hearsay evidence is allowed, like some treaties, customs, and traditions. That is, in exceptional cases, this particular oral or hearsay evidence is also allowed. Now, what is this concept of hearsay evidence? Even though we have discussed, hearsay means it's not a direct evidence; it's a secondary, rather you can say, and therefore, in order to avoid the ambiguity, in order to avoid the misleading the court and misleading the parties, the law strict way saying that hearsay evidence is not allowed. And this particular principle of hearsay evidence is based upon the Latin word that is very important. That is called as falsus in falsus omnius. That means one false thing again, false. That is false in one, particular false in all. Say because there is a chance of veracity, that is chance of addition, and therefore the person who has not experienced by five senses, he cannot depose. His evidence is called as the hearsay evidence. So apart from this, there are several reasons why the hearsay evidence should not be allowed under in the law. One of the reason is that there is the person who is deposed or depend or stated before the court, he has no responsibility because he simply say someone has told me. So there is no responsibility. And in court of law, the person who is going to take the responsibility on the oath, his statement, his version is allowed. Second, most importantly, that there is a chance of uh, addition, addition in the version. See, it is a tendency of the human being. There is addition in the version, and therefore, or there is a chance of fraud also, and therefore, this particular evidence is not allowed, and therefore, hearsay evidence is subject to the certain restrictions is not allowed. To this rule, there are 5 to 6 restrictions are there. In certain cases, indirect evidence or hearsay evidence is allowed, as we have already discussed, especially the uh, say for instance in case of the statement of the person who is dead, section 32 sub clause 1, we have already discussed, we call dying declaration. In that case, his statement is allowed because the principle for accepting the dying declaration is something base we have already discussed. generally generally it is based upon the person who waiting for it is not telling lie. All these aspects we will discuss. Therefore 32(1), this hearsay evidence allowed. Similarly, entries in the book, that is under section 34, then entries in public record, that hearsay where indirect evidence is also allowed. So all these aspects show that the even the oral evidence should be direct, subject to these restrictions. So with this, I hope you understand this initial discussion of the oral evidence. Now in next lecture we'll discuss the documentary evidence. Thank you.